Hi, thank you all for joining us today. We're excited to host and record this webinar on maximizing the online economy and making the most of your copyrights or your creative content as artists in the world. This is the first of a three-part series, and today's webinar will be focusing on the music industry, information most relevant to musicians and bands. I'm Meredith Badler. I'm the program director at the CBCA. I'm joined behind the screen with Rachel Henney, also from CBCA, will be helping to coordinate this webinar today. And then our speaker is entertainment attorney Max Hass, who will be leading us through today's content. I wanted to make a few remarks and housekeeping items before we dive into the content. This program today is presented in conjunction with sort of two different programs at CBCA, Colorado Attorneys for the Arts, or CAFTA, which is a program we've had at CBCA for quite a while, which connects artists and creative entities with free legal help and legal education, which today is connecting to, as well as a program called Advancing Creatives, which is general professional development and business skills for artists. I wanted to thank some of our sponsors for those programs. We've gotten some generous support from the Kenneth King Foundation for Advancing Creatives, and Colorado Attorneys for the Arts is supported by Colorado Creative Industries, Create Denver with Denver Arts and Venues, and the Colorado Bar Foundation. For today's webinar, we will be sharing our screen. We'll be switching over in a moment, so Max will be sharing his screen and walking us through his content. As a participant, you are muted. You will stay muted as a webinar best practice, unless there's moments that we want to unmute people or have sort of a verbal conversation. But you can send questions or comments or ideas or various thoughts via the chat feature. You can chat to just us, the panelists and the hosts. You can chat to everybody, everyone who's on the webinar, and that's a great way to share those questions. There's also a Q&A feature on your webinar where you can submit questions, and we'll be keeping an eye to that. You can raise your hand. So there's lots of different ways as an attendee that you can participate with the content, share questions. While Max is giving his presentation, the rest of us will be on mute and we'll turn our videos off so you can focus on that content. But please stay engaged through the chat. Send us questions. We'll be moderating that and monitoring it throughout the presentation. So if there's something you want him to repeat or you didn't quite get, send that through the chat feature or the Q&A feature, and we'll be able to respond to those in real time, as well as there's plenty of time at the end to go over questions and things that need additional clarification. So with that, it's my pleasure to introduce our speaker for today. Max Hass is a entertainment and business attorney based now here in Denver. He's also a musician and has had a variety of jobs in the music industry, working with bands, booking bands. So this is definitely within his wheelhouse, and we're excited to hear his content today. So with that, we're gonna do the screen share switcheroo. I'll close ours and then have Max pull up his and start the presentation. Go ahead, Max.
All right, thank you so much, Meredith, and welcome everybody. I appreciate you all for being here and being part of this. As Meredith mentioned, this is a workshop where we're focusing on how copyrights work within the music industry and how you can make the most of those copyrights by making sure that you really have a solid understanding of how they work and what you can do with them, as well as opportunities to monetize, commercialize your work online. Two major reasons that we thought this would be a good thing to do at this point in time. First, obviously, most musicians I know have lost a significant chunk of their income because live performances have been canceled. But the other thing is that there's now also a lot of time to sit down and actually figure out copyrights and ASCAP and BMI and things that maybe you've been meaning to really dig into, but didn't get around to it. Now's a good time to do that. So without further ado, I'm just going to get right into it. So before we officially get started, I just always have to kind of mention, just to make sure I'm meeting my professional responsibilities, that this is only an education class. This is going to cover areas of law, but make no mistake that I'm not going to be providing general legal advice during this presentation. And if you do have questions or concerns about a specific issue that you have, I would ask that you refrain from bringing those up in the group chat or Q&A, and please feel free to just email me directly with things like that, because I won't be able to advise you publicly here with everyone else present. But that being said, we're going to get right into it. So just a little bit about me. As Meredith mentioned, I am an entertainment attorney and a musician. I started my law practice in New Orleans about 2.5 years ago after working for about 2.5 years as a manager, booking agent, concert promoter. I went to law school in New Orleans and basically lived there for about 7 years before relocating to Denver 6 months ago. My core clients are musicians, filmmakers, artists, of pretty much all kinds. So I hear about the issues that artists are dealing with on a regular basis. I know what concerns come up. I have seen a lot of the same legal issues come up over and over again. And so I hope that I can share with you some of the lessons I've learned from that to your advantage. So just a little roadmap for where we're going during this presentation. That way you kind of know how it all fits together and it makes sense. We're going to start with an overview of copyright, and we're going to take a little bit of time with that because it's really important that artists understand on a at least a basic level how copyright works, so that for those who are fully independent and running the show completely by themselves, you know how to license your music, you know how to negotiate deals. For those who have managers, attorneys, other people as part of their team, this overview of copyright will also help you sort of know the lingo so that you can have productive conversations with all of the industry partners that you'll be working with. We're going to briefly touch on some contract issues immediately after that, to sort of show you how important contracts are when it comes to copyright management. Once your works are created, you then have to be able to make sure that you're not accidentally losing your rights in them. So contracts are really important. We're going to do a little walkthrough of copyright registration. I won't be going through the entire process, but I'm going to at least show you where to start and discuss some of the reasons why copyright registration is so important. And then we'll close out with some content on the real meat of, you know, where you make your money in the music industry outside of live performances, which is these days pretty much entirely online. You know, there are some amount of physical sales happening, but we'll talk about performance rights organizations, opportunities for licensing, and how to collect some of the trickier royalties, things like mechanical royalties that artists typically can't collect on their own. They usually need to partner with somebody. So I'll walk you through a little bit of that. So like I said, we're going to get started talking about copyright basics. And so, you know, we will be going through this relatively sort of thoroughly and methodically, but I promise that this knowledge will be very, very helpful when you get to the point where you're ready to get some contracts together, or you need to register your copyrights, and definitely once you start dealing with performance rights organizations, because They will not assume that you don't know anything and teach you about this stuff as you go. They're going to assume that you already know what you're talking about, and will deal with you as if you know copyright and understand it well. So that's why we're going to focus on that. So let's get into it. So the first thing I just like to clarify for folks, because this is a pretty common misconception, is that there is a whole field of intellectual property that encompasses multiple areas of law. And so when we talk about intellectual property in a general sense, we're actually talking about three separate areas of law: copyright, trademark, and patent. And they are not the same as each other. They are created by totally separate federal statutes. There's a totally separate case law that deals with it. There is some overlap in the real world sense, because sometimes a product that you invent might also have some copyrightable elements, and vice versa. You might have a work of art that is also has some functional components and might be eligible for patent. But it's important to just understand that these are three separate areas of law. And so these terms, copyright, trademark, and patent, are not interchangeable. So when we talk about getting a copyright on something versus getting a trademark on something, we're really talking about a totally different form of legal protection. And I can get into that in more detail if anyone's curious to know more about trademark or patent, but this presentation will be focusing on copyright. So just briefly to illustrate, kind of good little guide to go back to is, think of copyright as covering your works of art. Trademark is going to protect logos and brands. Patent protects inventions. So really simple, somewhat oversimplified way of thinking about it, but it's a good just guide as you move forward to understand copyright is for art, trademark is for logos, patent is for inventions. So if you're ever in a situation where you're not sure which area of law applies, think about that heuristic first, and then it'll usually guide you in the right direction. So start with the very, very basics. What is a copyright? Well, it's a form of property. That's a really important concept to understand. It is a form of property that can be bought and sold or rented out, just like a piece of physical property. You want to sell your bike to somebody, you can sell your bike. You want to rent your bike out to somebody, you can rent it out. Same with copyright. You can sell it outright so that someone else owns those rights, or you can license it to someone where you retain ownership, but someone else has legal permission to use it. As a form of property, it's important to understand that it's actually separate and distinct from the artwork itself. So the easiest example I use to illustrate this is, you think of a painter, Picasso creates a brand new painting and sells it to somebody who is a wealthy art collector. He sells that canvas. All he's selling is that canvas. He's not selling any of the rights to the artwork itself. So that concept applies across all of copyright, which is you have the copyright as a piece of property, and then you have your artwork as a piece of physical property. Obviously, in the digital world, there's not that tangible physical art object in a lot of cases, but legally speaking, these are two separate things. You can sell the object without selling the copyrights, and vice versa. You can sell the copyrights to someone else who maybe has the business savvy to commercialize your work, while you retain ownership of the original if you want to keep it in your own home. Copyright is governed entirely by federal law, with some very small exceptions, which makes it different from most forms of property that are typically governed by state law. But what that means is that copyright law applies pretty much the same way anywhere you are in the United States. So these concepts we'll be talking about today, it doesn't really matter what state you're in. You get into case law, that's a different story, but the basic rules of copyright apply the exact same way to every single person in the United States, regardless of where you are. The copyright comes into existence at the same time the work is completed. And I will talk about that in a little more detail in a few slides, but it's important to understand that you don't just sit unprotected for some undefined period of time after you've created your work. It's not like you create your song and then you decide to register the copyright 3 months later, that in those in between 3 months, you don't have protection. In fact, you do have a copyright from the very moment the song is finished. But then registration is a second step you can take that gives you additional protections and other benefits under the law. So it's important to know that you do have these rights that I'll be discussing in these upcoming slides, regardless of whether you've actually gone to the Copyright Office and registered your work. An owner of a copyright has a set of exclusive rights, which means nobody else but the owner can exercise these rights for a limited period of time. That's how copyright is sort of defined, is that it's basically a monopoly over that particular work of art. Only that one person gets to control it. They're not legally obligated to share it with anybody else, but only for a set period of time. And when that time runs out, the work falls into the public domain and it cannot be owned or commercialized in the same way by anyone else again after that. So, you know, that's a little bit different from most forms of property. If you own a car, you have the rights to do what you want with that car for as long as you own it, for as long as that car exists, right? There is no point in time where a physical piece of property suddenly becomes public domain property. But copyrights are different. So that's just important to know that you have these exclusive rights, but at some point those rights will actually expire and nobody will be able to have those rights. So what are those rights? And we're going to actually repeat this slide again a little bit later on, but this is a really important list to pay attention to because these are spelled out in the copyright statute. So you have, depending on the nature of your work, you have either all 6 of these rights. Well, actually, nobody ever has all 6 of these rights. But for the most part, every copyright comes with the first 5 of these rights. Sound recordings include 1 through 4 and number 6, but not number 5. So those rights are to make copies, of course. That's sort of why copyright first came into existence. Naturally, if you reproduce copies of your work, you're going to also want to sell those and get those out to the public. So you also have the exclusive right to distribute those copies. You have the right to create derivative works, which are new works based on a previously existing work. So I'm not going to really dive into derivative works too much in this workshop, but a good way to think about that is when you have a movie that was based on a novel. That's a very simple example of a derivative work. The book was the original work. The movie is fundamentally based upon the characters, storyline, and other details that were copyrightable and copyrighted in that book. And then the film becomes a derivative work. So the owner of the rights to the book have the authority to authorize that film being made because that is within the scope of their exclusive rights of copyright. You also have the right to publicly display the work. This technically only applies to works that are capable of being displayed, but that's a pretty wide range of things. So films, visual art, if you wanted to print out your sheet music, you know, really anything that is capable of being put onto public display is, you have the right to make those public displays. You also have the right to publicly perform the work. So, you know, that doesn't apply to things that can't be performed, so to speak, of course, but it does, of course, apply to music, to dramatic works like plays and musicals, to films, things along those lines. One really important point to note is that the public performance right does not apply to sound recordings. There's a complicated political history behind that, but in the 90s, Congress granted sort of a limited exception to that that said, okay, we'll allow public performance rights for sound recordings, but only for digital audio transmissions, so streaming and internet radio. So you do have a limited public performance right in sound recordings. You have a full public performance right in musical compositions. So that's a little bit tricky, but it has immense impact in the music industry. And we're going to talk about that later when we get into performance rights organizations and SoundExchange. Okay, so there is a specific list that is in the copyright statute and that the Copyright Office uses to sort of categorize works when you go to register. These are the 8 categories that copyright law recognizes as being eligible for copyright protection. So you can see the list here. I won't read it all off, but I've highlighted musical works and sound recordings here because it's important to note that these are 2 separate types of copyright. These are listed separately because the copyright law and the Copyright Office recognize them as 2 entirely separate areas that are deserving of copyright. So when you have a recorded song, you actually have 2 copyrights at play. You have 1 copyright for the composition, regardless of how it sounds in the recording. There is a separate copyright for that. And then you also have a copyright for the recording. Worth noting here is kind of a minor point, but the sound recording copyright does apply to things other than music. So if you make, other types of recordings, whether it be ambient noise or nature sounds or whatever you feel like recording, as long as it meets the basic requirements for copyright eligibility, which we're going to talk about in the very next slide, then you can get a copyright in that sound recording. It doesn't have to be music. Another thing to note, these are the terms that the copyright law uses. We call the copyright in musical works typically referred to as the musical composition copyright, whereas the sound recordings are obviously referred to as the sound recording copyright. However, in the music industry practice has created a different set of terms to refer to these things. So it's important that I mention this because you're going to hear all of these terms used interchangeably. In the industry, the sound recording copyright is referred to as your masters. And it's a little bit of an outdated term because it originally referred to things like the master tapes. And if someone had possession of the master tapes, it generally implied that they also owned the copyright to those recordings. And so over time, it just sort of melded together so that the sound recording copyright was also referred to as masters. Musical composition copyright is often called publishing. So when you're talking to a record label about your recordings and you hear them talk about masters, they're talking about the sound recording copyright. They're not talking about your audio files or your tapes or your hard drive. Obviously, there's a possibility they might be talking about that. Context is important. But from a legal standpoint, if you're looking at contracts that are referring to things like masters, it's referring to the sound recording copyright. Okay, so even if your work of art falls into this list, you still have to meet these threshold requirements. So you might have a sound recording, but it's literally just you sticking a microphone out the window and not doing anything else. It's possible you might not be able to get a copyright there because it has to be an original work of authorship. There has to be some minimum degree of creativity that is exercised in the creation of the work. It also has to be done by a human author. So AI created things and works of art that are created by animals, those cannot get copyright protection. I guess in theory, if you created a painting with your dog, you could maybe get a copyright for yourself and give credit to your dog or something like that. But outside of sort of the absurd example, generally it has to be a human author in order to receive a copyright. The second important threshold requirement is that the work must be fixed in a tangible medium of expression. That means two things. It has to be somewhere other than just in your head. So it has to be out there in the world in some way. But it also has to exist for more than just a really short period of time. So you, if you maybe make a drawing in the sand at the beach, or you draw something in chalk on the sidewalk and you never document it, you never take a photo or something like that, those aren't going to really count as fixed because those will get washed away very, very quickly, right? So, it has to be fixed in some way to where another person would be capable of seeing it or hearing it and could copy it from what they've seen or heard. If it's not fixed and it wouldn't be possible for someone to actually copy your work, then it can't get copyright protection. So if it's still just an idea in your head, you don't have a copyright yet. But as soon as you sketch it out on a piece of paper, let's say it's a song, as soon as you write the lyrics down on a piece of paper or on your computer, it doesn't have to be in hard copy, that counts as fixation, and you will get a copyright at that point once it's fixed. But until you do that, it's impossible for you to get a copyright on it. Okay. I'm going to take a minute here to make sure I'm not missing anything in the chat.
Hey, Max, it looks like we have a question. Someone asked, can you define fixation?
Yeah, I mean, it's basically just some kind of recording, right? So, if you have an iPhone or even any kind of phone that can record audio and you record a demo of yourself playing something, that will count as fixation. All that it has to be is something that isn't going to just disappear in a matter of a few seconds, right? So even with my sandcastle example, that could be fixed if you took a picture of it, right? You have it, the design of that sandcastle, whatever, fixed in an image. You can get a copyright in that photo, and possibly even in the sort of sculptural work, because it's been documented in a way that someone else could come along and see it and be able to copy it from that. But if there's no way for somebody to do that, then it won't count as fixed. So I think we've got that covered. Okay, so let's move on here. Kind of already said this, but just to really make sure this point is clear, you get the copyright as soon as that fixation happens. Assuming you've met all the other requirements, that it's a type of work that copyright law will protect, and that you have that minimum degree of creativity, the copyright's going to come into existence at the same moment that you have finished the work. Okay, so as soon as if you're recording something, as soon as you hit stop record, copyright begins in that recording, right? And possibly even the song that you've recorded. So you could theoretically have two copyrights that come into existence at the same time. Like I said earlier, registration is not required to have a copyright. All you have to do is create the work and you have a copyright. Registration is very important for other reasons, though, and there are a lot of additional benefits and legal protections you'll get from registering your copyright. We're going to talk about that later on. But I really want to drive this point home, is that you have these rights from the very moment that the work is finished. And so once you have that, you can do things like license your work, sell it to somebody else, make copies of it. All of those things that we're going to be talking about throughout this presentation, you have those as soon as the work comes into existence. I still highly recommend registering, and I'll tell you why later on. But all right, so just to sort of round out your understanding here, there are some things that can't be copyrighted, things that aren't fixed, that are still ideas in your head, basic symbols and shapes and other things that are used as sort of building blocks for anybody to be able to use to create something. The law and sort of the principle behind it is that we don't want to allow someone to monopolize something as simple as, say, like a basic circle, because then nobody else would be able to create something with a circle in it without getting permission from the copyright owner. And that's kind of a ridiculous thing. So, if there's no originality in the work, if it's just a simple listing of items or, very just generic factual description of something, it probably won't meet the originality element. Simple variations in typography, kind of a fuzzy area, but for the most part, just changing the font on something isn't going to be enough to say, oh, I have a copyright over this, because it doesn't really rise to the level of originality that copyright law requires. Another important point, which was a big fight in kind of the late 90s, early 2000s, was whether or not a copyright could exist in a web page. And what courts have basically said across the board is that the layout or overall look and feel of a web page is not eligible for copyright. So the concept of having, a navigation bar across the top of the screen or a contact button in the upper right corner, those are not the kinds of things you can get a copyright over. You can get a copyright in the text that you write on your website and the photos that you've put up there, any designs or other things that would count as copyrightable artwork or literary works certainly could go up there. And in fact, even quite a bit of computer code is eligible for copyright protection as well, but the overall basic layout of a web page is not. There's also kind of a secondary list here. There's certain things that are expressly excluded from copyright law because they're covered by other areas of law. So anything that's sort of functional or useful or is a process or system, all of those things fall under patent law. And so copyright is not going to extend protection to those kinds of things. Doesn't mean you can't get protection for them. You just have to do it under a different set of laws. A really important thing that I get this question actually pretty often is with things like titles and names, those can't be copyrighted. So you might have, an album of 10 great songs. You can get copyrights in the songs and in the recordings, but you can't get a separate copyright in the title itself. The name of the album is not something that you can protect under copyright law. And in fact, in most cases, even though I'm note here that's covered by trademark law, a lot of times titles are not necessarily covered under trademark law either. And I can explain that offline if anyone has questions about that. But it's important to note that things like logos, brand names, your band name, other things like that, you won't fall under copyright law. They're going to fall under trademark law instead. So it's sort of a different analysis that you have to do. And just important to know that when you do go talk to an attorney or somebody who's helping you with your music business, that copyright's only going to extend to the creative expressions and not to the sort of labels and descriptions you've used for them. Okay. So that's sort of the really sort of first step basics of copyright. So we're going to take another step a little bit deeper here. So now you understand sort of what a copyright is and what are those rights that you get. The next really important aspect of copyright to understand is the concept of an author and the owner. These are two terms that have specific legal meaning under the copyright law. So it's really important to understand what each of these terms mean and how to identify the authors and the owners of a copyrighted work. And we're going to spend a couple slides on this. So we're going to talk through a few different situations where questions about authorship come up, because obviously there are situations in which there's only one person involved in the work of art, but more commonly, especially when we're talking about music, and on Friday we'll be talking about film. A lot of creative stuff out there is created collaboratively. So if you have multiple people working on a project, you run into authorship issues very, very frequently. So that's why we're going to focus on this. So let's just start right at the top here. Author is a person who makes any kind of non-trivial creative contribution to the work. So if that person has met the sort of minimum degree of creativity standard that we talked about a few slides back, and they were part of the project, then they're going to be considered an author. Now that could just be one person, like I said, or it could be multiple people, but anybody who has made a contribution to the work that itself would be independently copyrightable is going to make them an author. Now, one thing that's interesting here is that if someone counts as an author, the law says that they are automatically an owner of the copyright. So if you write a song, you're also going to then be the owner of the copyright in that song. Pretty simple, right? So the owner is defined as the person who has control, legal authority over the work. So they're the one who has to sign off on any kind of major decisions about the work. So if someone approaches a copyright owner and wants to license a piece of music from them, it's the owner who has to sign off on that. Now, the owner and the author can be, and very often are, the same person, right? But they don't have to be. So you could have a songwriter who has a publishing deal where he's signed over a portion of his or her song copyright to the publisher. So if the publisher then becomes the owner and someone wants to license that song, they have to go to the owner to license it. They can't go to the author if the author has no ownership stake at all. And we'll talk about that a little bit more later on. But the idea here is that when you start getting into contracts and start licensing out your rights and other things like that, that the question of who owns the rights is going to be very, very important for both legal and financial reasons, because that is the person who has the authority. If you get a license from someone who isn't an owner, then there's sort of some doubt as to whether that license is valid. There might even be some issues of copyright infringement if someone is licensing your work without authority. So identifying the owner is an important thing to do. When there are multiple authors, we're gonna dig into this concept more over these next 3 or 4 slides. But where there are multiple authors, the default rule in the law is that they're going to be co-owners with equal shares. Co-owners with equal shares means that all of the people who helped contribute to the work as authors are going to equally have a stake in the rights themselves, and therefore any money that might come in related to the copyright. And they're also able to basically exercise those 6 rights that we talked about earlier. So ownership and co-ownership can be modified by contract, but without a contract, this is going to be the default provision, the default situation. So that's why we're going to talk about the multiple author situation. So first, just the simple case, when you have one author, the author is the only owner of the copyright and has the exclusive control over the work, gets to exercise all of those core rights we talked about earlier, gets to collect all the royalties, gets to issue licenses, has the authority to sell the copyright if they choose. If you're in a situation where there's just one author, you can skip right ahead to copyright registration. You don't have to worry about contracts. You don't have to worry about making sure that, you know, you've gotten people to sign off on anything. You can take your work and you can go and register it and get right into licensing and monetizing your work. But we know that that's not always the case, right? You might have a co-writer, you might have a producer, you might have a whole band of session musicians that you hired for a recording session. So there's a few different scenarios where multiple authors play out, and they kind of play out differently under the law depending on the context. So we're going to get into that. But just so that you're aware, if you created something without anyone else's involvement, you're in a pretty good position, and you usually can go right to registering your copyrights. So just a sort of high-level overview, there's 3 scenarios that I have encountered time and time again with my clients, as well as myself being in a band and things like that. And so, you know, there are different variations of how these play out, but these are the 3 scenarios I'm going to be talking about in this presentation because I see these come up over and over again. And I hope that it's sort of a good salient example for those of you who have been in these situations. So the first scenario we'll talk about is what I call a true collaboration, where you have 2 people on the same footing, and they come together because they want to create something together. It's not one of them hiring the other one, it's more like a partnership, right? So an example of that is 2 people just coming together to write a song. Someone writes the music, someone writes the lyrics, or maybe they each write a little bit of both. That's a true collaboration. In that scenario, you're going to have the legal status under the copyright law as being co-authors in a joint work. We're going to talk about that on the next slide, but that is a specific legal status that affects your ownership and your ability to do things with the work. So true collaboration will put you in that position. Scenario number 2 is where the artist or whoever's in charge of the product or the project hires help, right? So classic example of that is maybe you're a band leader or a composer, and you want to go into a studio for a recording session, but you want to hire specific musicians to get the right sound for your album. Hired guns, right? If you're bringing people in, you're in charge, they're working for you. That's very different from sort of the true collaboration situation. However, without a contract, the law will pretty much see it as the same thing. And so this highlights why contracts are so important, because you might have a verbal agreement or an understanding with your collaborators that they work for you and that you're in charge, but without legal documentation to establish that, it can always be called into question because the default rules in the copyright statute are going to say otherwise if there's no contract. And like I said, we'll get into that in more detail. And then the third scenario is where the artist gets commissioned to create something by somebody else. So that could be a company who's hiring an artist for a one-off thing. It could be some wealthy art patron who just really wants to support an artist and wants a custom song written for them. But whatever the case is, whoever the hiring party is doesn't really matter, because this is a very different type of legal situation where the artist is the one being hired. Again, an area where contracts are very important. So we'll get into that as well. All right, so let's start with the first scenario, a true collaboration. So the key question here is to figure out whether you are co-authors in a joint work. So first off, let's define joint work. This is a paraphrase of the definition that's used in the copyright statute. But a joint work is a work where two or more artists come together to create a work with the specific intent to merge their talents into one inseparable work. In order for you to qualify for that, each person's contribution has to be independently copyrightable. Remember, I said that a few slides back, right? If someone has made a non-trivial creative contribution to the work, it will be independently copyrightable. So, there's not a clear line as to what counts as copyrightable and what doesn't. It can get a little bit fuzzy. But a good sort of general rule to think about is, if someone just added maybe one word of lyrics to your entire song, their only contribution was one word, that's going to count as trivial. So don't need to worry too much about that. The other really important piece of this is that all of the parties involved must intend to be collaborators. They must have that subjective intent to collaborate with one another. So if you create a song and then 5 years later, someone finds it floating around on the internet and adds, a vocal part over it, that's not an intent to be collaborators. So that won't be seen as a joint work. And so those two people will not be considered as co-authors in whatever that sort of new song is that gets created. Without a contract, co-authors are automatically going to be co-owners, right? So I mentioned that on the previous slide. So a good sort of test to use, if you think you might be in this situation, there's basically 3 questions you can ask to kind of help figure this out. So the first one is, did each person make a copyrightable contribution? So it has to be an original work of authorship and it has to be fixed. Second question is, did all of the collaborators intend to collaborate with one another? It's a really key question. If the answer is no to that, then you can pretty much stop right there. And then related to that second question, but still worth asking separately, is, did the creators intend to create one cohesive work as a result of the collaboration? So if someone wrote some lyrics but didn't necessarily intend them to go to a particular song, then the answer to this question might be no, right? So the idea is that co-authors in a joint work will come around where 2 or more artists are getting together with the specific intent to create something together. They're getting together for a writing session. They're sitting down next to each other, working on a song together. They're in the studio working on a song together. If the answer to all three of those questions is yes, then you're going to have co-authorship. If the answer to any of those three questions that I just listed is no, then you might not have co-authorship. So it can get a little bit tricky and a little difficult to figure out. So if you're going through that list and you're trying to figure out, did we really intend to create a song together? I think yes, but this other person thinks no. That might be a good moment to maybe get in touch with a lawyer and see if they can kind of help untangle the situation for you. So before we go on to the next scenario, I just want to talk about sort of what happens when you have a co-authorship. The default rule, and again, this is the default provision. So this is what the statute says, but you can always modify these rules with a contract. So these are the rules that are going to apply if you don't use a contract. And really, these are the rules that will apply up until that point that you have a contract in place. So that's one of the reasons why I always recommend to clients that, if possible, try to get a contract in place before the work is created, because then you will never have to worry about these default rules. But if you create the work first and then you get a contract, there is a period of time in between where the default rules will apply and could create some challenges for you when you try to get someone to sign a contract. Because if they've already spoken to an attorney who tells them, you're in a good position right now, it might create a situation where they're a little less inclined to sign that contract. So that's just, something to be aware of. But let's go through this. The co-authorship means co-ownership, right? So if you're co-owners, the copyright law is going to assume that you each own the copyright in equal shares. So if it's two people, it's going to be 50-50, three people, 33% each, and so on, right? So, the copyright law is going to be as sort of neutral and equitable as possible in the sort of basic default rules, but you have full freedom to change those numbers. So you could get together with somebody and you're, each contributing 50% to the song, but one person is going to put in a lot of work in trying to distribute the song and get that out there. Maybe you put a contract together where you decide you want to split it 60-40 or 70-30 or any numbers you choose, really. That is perfectly allowed. But if you don't have a contract, it will be 50-50. Related to that, co-owners have the full right to use and enjoy the benefits of copyright ownership. So even if you only own 50% of a copyright, you can still exercise those 6 rights we went through earlier, right? There are some limitations to that. There's some exceptions, but it's pretty similar to the notion of co-ownership of a piece of land. If someone and their brother co-own a piece of land, both of those people are free to use the entire piece of property, right? It's not like their 50% interest means that one of them has to keep to 50% of the land, the other one has to keep to the other 50% of the land. They can both use the whole thing. And then the same concept applies in copyright. So even if you only own a percentage interest, if there's no contract in place, you still have the right to make copies, to distribute those copies, to issue licenses, public performances, public display, and so on, okay? So let's get into some specifics of that. You can collect 100% of the revenue. However, you are obligated to pay your co-owners in proportion to their shares. So 2 co-owners, they each own 50%. If owner number 1 goes out and licenses the song and brings in thousands of dollars in revenue, even if that person did all the work, they're still legally required to pay the other co-owner their 50% share. That's also something that can be modified by contract. A co-owner can also grant non-exclusive licenses without needing to get the other co-owner's permission. So if someone comes to you and wants to offer you a sync license and get your music in a new film that's coming out, as long as that license is non-exclusive, you don't have to get your co-owner's permission to issue that license. You do still have to pay them their share of the revenues that come in, but you're allowed to issue that license and engage in commerce without needing to go back to your collaborators. However, on the other hand, if that's an exclusive license, meaning once that license is granted, that film production is going to be the only party with the right to use your song, and you can't issue licenses to anybody else while that exclusive license is in place, then you do need to go and get permission of your co-owners. Similarly with assignment. So assignment is a term used in copyright, trademark, and patent law as sort of the IP version of buying or selling something. So when you assign your copyright to somebody, you are selling the rights. That bundle of 6 rights we talked about, you're actually selling those outright to someone else so they become the copyright owner. You can't do that without getting permission of your co-owners. You can't sell the entire copyright without getting the other co-owners to agree to sell the entire copyright. Little twist to that is you can sell your interest. So if you and another person own a copyright 50-50, you can sell your 50% share. You just can't sell the entire copyright to somebody else. You can't create a new owner of the copyright without making sure that all of the existing owners approve of that sale. And then one other very important point is that co-owners cannot sue each other for infringement. So if taking the 2-person example again, if one person issues a bunch of licenses, gets the music out to a bunch of films, and the other co-owner doesn't like that and didn't approve of it, they cannot sue for copyright infringement against that other co-owner. Now, if you're a copyright owner and then there's another person over here who isn't a co-owner of that copyright, and they issue licenses to your song, that is infringement. You can go after that person. But if you're 2 co-owners of that same copyright and co-owner 1 issues licenses and co-owner 2 doesn't like it, there's no legal action of copyright infringement available there. Federal courts will not even allow you to file a lawsuit on that. So that's a little bit of a kind of advanced concept, and we probably won't really get into that too much, but just important that you're aware of that, so that if you are in a co-ownership situation, there are different ways you're going to have to go about enforcing your rights. You can file suit, for example, to claim royalties and other revenues that are owed to you, but you just can't frame it in the context of a copyright infringement action. All right, so I'm going to try to pick up the pace a little bit here because I know that we're going to have to cut off at 1 o'clock here. But so getting into the second scenario where an artist hires help. This is actually a pretty quick slide, so we'll get through this quickly. Kind of went through this already. The artist is in charge of a project but needs other people to help execute it. So in music, that might be your studio musicians, that could be your producer, could be your engineer. In that situation, the default rules, copyright law is going to see you as just equal collaborators. And so without a contract, the law is most likely going to treat you as co-authors, and then you will automatically become co-owners. So that's where a contract becomes very important, because if you hire studio musicians and you have a contract that contains a copyright assignment clause, you can actually have that studio musician transfer their interest in the copyright to you as the project leader, and then you will not have to worry about them being a co-owner down the road. If you pay them some flat fee for the recording session and they give up their share of the copyright in exchange, then they're not entitled to any future royalties. And so you minimize that risk that there are going to be people coming out of the woodwork later and demanding that you owe them a bunch of royalties from 5 years ago or something like that. So that's really important. Without a contract, the default rule is going to make you co-owners. So if you hire, let's say you have a big project and you hired 10 different studio musicians, and you have a producer, and you worked in 2 or 3 different studios and you had a different engineer at each one, there's potentially a dozen other co-owners you have to worry about. So it can get very complicated and very out of control really easily without you really doing anything other than just running the recording session. But when the time comes to do something with your copyright, if you don't have full ownership of it, it's going to make it a little bit harder to sort of take those steps to monetize. Okay, so now we're getting into an area that's a little bit more complicated, and I do want to make sure that people understand this, but I also don't want to spend too much time on it because we have a lot of other important stuff to cover. So if anyone is confused by the stuff that I'm talking about on these next two slides, feel free to email me and we can talk offline about that. Okay, so third scenario, a company or some wealthy patron commissions an artist. There is a possibility in that situation that the work for hire doctrine might apply. Work for hire doctrine is a special concept within copyright law. I'm going to talk about on the next slide, but it comes up pretty frequently where an artist is hired to create some kind of commissioned work. An important question to ask there to sort of help determine whether work for hire applies is, are you a W-2 employee of that company or of that person who's hiring you? If so, you might be in a work for hire situation, and so you have to really look closely at those details. If not, though, a contract is going to be required. Now, this can get a little thorny for artists. I've had actually quite a few clients who've come to me with legal issues involving this exact situation. Even though the hiring party is paying for the project and approached the artist, specifically commissioned them, requested them to create something on their behalf, the work for hire doctrine does not automatically apply just because someone paid you to create something. The reality is, under the copyright law, that if there's no contract, the artist is going to be considered the author and the owner of the rights, because they were the one who had the original work of authorship and fixed it in a tangible medium of expression. And if they're the only ones who did that, they're the only ones who are going to have the rights that are established under copyright law. Now, in commission situations, the hiring party, because they're the ones who spend the money, they always think that they own the rights just because they paid the artist. Always happens. But the legal reality of the situation is actually the opposite. So that's where contracts, again, become very, very important, because if that hiring party wants to buy all of the legal rights from you as the artist, they must do so in a written contract, or else you retain all of those rights. So, there's a lot of different ways that can play out, and there's a lot of different examples and other things we could talk about, but I'll just leave it at that. So I'm going to just briefly touch on the work for hire doctrine. Now, there's one thing I have to say here for this particular presentation to be aware of, is that the work for hire doctrine in copyright law, for the most part, does not apply to music. Not across the board, I say for the most part, because there are some ways in which it could apply to music. But most of the time, musicians work as independent contractors, and work for hire doctrine does not apply to music. But still important to know about it. It still can come up in different ways. You'll still have companies and patrons and people who hire you for commission projects who think that the work for hire doctrine applies. And so this is something that's important to kind of get it all straight, because that's going to affect your legal rights in terms of what you own, what you can do with the work, what the hiring party can do with the work, and so on. So of course, this comes up in the situation where an artist works for a third party creating a specially commissioned work, right? So, and I'm actually going to skip this middle section for a second and just talk about the point here at the bottom. If work for hire applies, and if all of the requirements are met, the result is that the hiring party becomes the author of the work, which is kind of a weird concept. They actually are able to take authorship away from the artist if the work for hire steps are followed properly. and then of course becomes the owner of the copyright. But the reason that's important is because if the artist is never considered the author, then their name never has to go on the copyright registration. They don't have the termination of transfer available to them, which is a more complicated copyright concept that I can talk about offline with people, but still very, very significant, especially in the music business. And basically the company has total sort of comprehensive control over that copyrighted work. It does affect the duration rules. So we talked about duration briefly at the beginning, 70 years after an artist's, the artist's lifetime plus 70 years if it's an individual author. But if the company is considered the author, then there's actually a different set of rules on how long that copyright lasts. One of the most sort of well-known examples of sort of work for hire out in the entertainment industry is, take like Disney, for example. Everybody who works for Disney is basically subject to the work for hire doctrine. And so Disney is considered the author of the films it produces, not the directors, not the animators, not any of that. Disney as a company is considered the author of those works. So requirements for work for hire. There are two different ways that work for hire can come up. First is the artist is actually a W-2 employee. You go to work every single day at the same place. They provide you with your workplace, your equipment, your tools, your materials, whatever you need to create. And then your job involves creating something for your employer. If that's the scenario you're in, work for hire will apply. That's the only requirement, is if you're an employee and you get a regular paycheck, you get taxes withheld, things like that, work for hire will apply. So that's the one way in which work for hire can apply in the music industry. But I personally don't know very many people who are W-2 employees in the music industry. So unless you're in a very unique situation where you actually are employed in the business of creating a copyrightable work. So the probably best example I can think of is a professional songwriter who's not otherwise a recording artist or a live performer. They have a lot of them in Nashville these days. They go to work every single day in an office owned by a publishing company, and they are salaried employees of the publishing company. Writing songs is their job. In that situation, assuming they, meet all the other requirements of being an employee, work for hire actually could apply. But as we all know, most musicians work as independent contractors. You're freelance, you're bouncing around from one gig to the other, from one recording session to another. So you're almost never in a situation where you're a W-2 employee, right? So the other alternative is that you're an independent contractor. Now, if you're an independent contractor, the only way that work for hire can apply is if the work falls into a specific list of categories that's actually listed in the copyright statute, and music is not on that list, and sound recordings are not on that list. And there is a written signed contract that specifically says the work is made for hire. That is in the copyright statute and was affirmed by a Supreme Court decision in, I want to say the 80s, but I might have the year wrong. But very, very, very important here. If you're an independent contractor, the work has to fall on that list of 9 categories, and there has to be a written contract. Otherwise, work for hire does not apply, and that hiring party cannot be considered the author of the work. Okay, so I'm going to leave it at that because, again, this is not something that comes up very often. Sometimes can come up in termination of transfer issues, but termination of transfer is not going to apply to, I'm assuming, most of the people who are in this presentation right now. Typically applies to musicians who are a little bit older and have record deals from the 60s and 70s and 80s. But work for hire still looms large in the copyright world, and you'll hear people talk about it. So it's important to understand that. So just to kind of circle back, we've got these 6 exclusive rights. I just wanted to sort of put this up here as a reminder. This is why these issues of authorship and ownership are so important, because if you're an owner, you have these rights. If you're not an owner, you do not have these rights. So if you have a collaborative situation and there's confusion about who's an author and who are owners and whether you're co-owners, this is what's at stake right here, is this list of things. And these legal rights are what entitle you to get paid for your work. Copyright law serves as the core value that your music has. Without that copyright law and without this protection of these 6 exclusive rights, you wouldn't be able to demand licensing fees. People could just find another way to use your music. So that's why this stuff is so important. So we're going to shift gears slightly and talk very briefly about contracts. There are basically 2 different categories of contracts that are to think about here. You've got the contracts that come up kind of during the creation process, ideally before, but the reality is that, you know, we kind of do all this stuff in parallel. And the key thing there is establishing a clear chain of title over the copyright. So this is when you have hired help or collaborators, or someone hires you as an artist to do something to create a commissioned work. The contracts that you use in those early stages are going to establish that clear chain of title so that there's no confusion later on about who owns the copyright and who can monetize it and who can authorize licenses and so on. The second area of contracts to think about is what happens after the work is finished and you're ready to take it to the marketplace. At that point in time, you're looking more at things like licenses and assignments of copyright, or bigger contracts like record deals, publishing deals that include assignment clauses, right? So those are the 2 categories. So we're going to talk a little bit about clearing chain of title. So examples here are things like your agreements with your studio musicians, co-writer agreements, producer agreements, split sheets. Usually there is a clause that assigns copyright interest to another person. So if you're a band leader, you're trying to get all your session musicians to give up their copyright. The idea is you might have, say, 4 other people in the studio. Without contract is going to be 20% each, right? 1/5 ownership. So the idea is you use these contracts to take that 20% back from everybody else, and you consolidate 100% ownership in you as the project leader. Once you do that, you can then go out and license, enter into record deals, all kinds of other things without having to worry about whether these other people might claim royalties or claim co-ownership or other things down the road. You can use those contracts to indicate who will get authorship credit in the liner notes and other places. You can also use it to indicate who has administrative rights. So in a co-writer agreement, you might contractually agree that you're going to remain co-owners, right? You might want to give your fellow songwriter a piece of ownership in the copyright, but maybe you are the more business savvy one and you're going to be the one doing all the licensing and all the other things. You can give yourself administrative rights, which means that the other co-owner doesn't have the legal right to issue licenses and other things like that. We can talk about administrative rights later if people have questions about that. But this is a good place. These types of contracts are a good place to indicate who gets the administrative control over the copyright. Obviously, you also want to include terms for payment, right? So whether you're paying somebody up front or whether you're agreeing to pay them royalties on the back end, either because you don't have the money up front or you want to sort of cut them into royalties because you think the song will be successful. These types of contracts are a good place to establish that kind of thing as well. If you're dealing with commission projects, some sort of employment agreement or an independent contractor agreement will usually be used. If it's an independent contractor agreement, it's going to have either a work for hire clause in it or a copyright assignment clause in it, or maybe both. So that's an important thing to look out for. And then, you know, the reason this is important, like I said, is once you have that clear chain of title, it's going to be relatively smooth sailing when you start making deals with larger industry players. So if you approach a record label and you're trying to get a record deal, and they ask you, well, who's on this record? Do you have contracts with them? The reason they're asking that is because they don't want anybody coming out demanding royalties later on. They want to make sure that you have that clear chain of title so that they can be protected from any kind of headache and other hassles later on. All right. And then, the flip side is after you've done all that, you've got your contracts to monetize your copyrights. So your license agreements might be for sync licenses if it's going into film, TV, commercials, whatever. It could be samples. If another musician wants to use a sample from your song, they have to get a license agreement from you. You might partner with some music libraries, in which case you're not only licensing your music to the library, but then the library is also licensing your music to other people. So that can be a big source of revenue, but comes directly from your control and ownership of those copyrights and your ability to legally authorize those licenses. Another big area is obviously record deals and publishing deals. In those situations, you're usually going to be encountering some kind of assignment clause. Labels traditionally will take 100% ownership of your masters, right? So they're going to have an assignment clause that says you as a recording artist agree to transfer all copyright ownership in your sound recording copyrights only, not the compositions, to the label. And in exchange, the label pays in advance, does some marketing and promo for you, hires publicists, things like that, right? Now, things are changing in that area. More modern record deals are shifting to more of a licensing model, but we're not really going to talk too much about that. And then similarly, publishers, and this actually is still true, in sort of a standard publishing deal, publisher is going to take your 50% ownership in your musical composition copyright. And they're also going to probably include an administration clause in there where the publisher is going to take 50% ownership and also will be the only party with legal authority to issue licenses. Publishers like to do that because they don't want to be out there trying to pitch your music and all of that, only to find that the songwriter is also pitching their music and maybe charging different prices. Publisher wants to really control that, and they usually sort of secure their investment by taking an ownership piece in the copyright. All right, so that's all we're going to say about contracts for now. But of course, if anyone has questions about contracts, feel free to bring those up and we can talk about them. So we're going to talk a little bit about copyright registration. First thing I'm going to do is just kind of show you, in case you've never been to the Copyright Office's website, made it real clear here that register is a big square on the left side of the page. Click on that, and it's going to take you to this screen. Down at the bottom, you'll see this button to log into the ECO registration system. And then it'll take you to this next screen once you click on that button. If you don't have an account yet, of course, you'll need to create one. But then once you log in, you'll be able to register your copyrights, keep track of any pending registrations that you've already submitted. You can save drafts. You don't have to do it all in one sitting and things like that. So that's just to orient you about that stuff. And now we're going to talk just briefly why this is important. Copyright registration is very strong proof of ownership. And like I mentioned earlier about clear chain of title, registration of copyright is going to be essentially required if you want to get a record deal or a publishing deal. That's part of that chain of title, is not only that you have those contracts in place with your collaborators, but that you've also taken that step of registering the copyright with the U.S. Copyright Office to put the general public, the whole world, on notice that you own that copyright. Another reason copyright registration is important is very practical. You cannot file a copyright infringement lawsuit unless you have a registration. The Supreme Court just ruled on this actually last year. It was something that we generally knew was true already anyway, but the Supreme Court clarified it to make it a very clear rule throughout the country that you cannot file a copyright infringement lawsuit unless you can also provide proof that you have registered the copyright, and in fact, that you have the registration certificate in hand. So you need to have that certificate, and include it when you file an infringement lawsuit. So if you haven't registered the copyright, you're going to have to do all of that before you can even get into court. There's also special benefits you get if you register within a certain amount of time. So if you register your copyright within the first 3 months after you have published the work, made it available for the public to download, stream, etc. Within those first 3 months, if you get to the Copyright Office and submit your registration, then for the rest of the time the copyright is in existence, for your entire life plus 70 years, you will be able to claim statutory damages and attorney's fees if you find yourself in a copyright infringement suit. Statutory damages basically means that you don't have to go provide evidence of how much money the other person made from their infringement or how much you lost from their infringement, but instead is basically a sliding scale that the judge gets to determine is sort of the appropriate amount of damages you're entitled to. And that comes up where proof is hard to find, right? You know, if sales are difficult to track, or if you don't have access to financial documents, or if everything was done in cash and there's no records, you can use statutory damages as a way to still get financially compensated for the infringement without actually having to spend years gathering evidence. Attorney's fees are also important because you can make the other party pay for the lawsuit if you win. Because the idea there is you wouldn't have to file an infringement lawsuit in the first place if this other person didn't infringe. So these are two things that you have access to if you register your copyright within those first 3 months of publication. If you don't get in those first 3 months, you can register within that first month after you've discovered an infringement, and you can still get access to those things. But if you've missed both of those windows, you won't be able to request statutory damages later on in an infringement lawsuit. So huge area where registration can be a huge benefit for you. Registration fees are also really cheap. So I like to think of this as a very cheap insurance. You get all of these benefits, all of these important legal protections for registration fees that range from $45 to $65 per registration. So in a lot of cases, you can get an entire album registered for $65, and then you have your presumptive proof of ownership, you have the ability to file lawsuits, you have the ability to go after statutory damages and attorney's fees, all because you took that step of registering your copyrights and spent $65 to one time to get all of these benefits. The other reason registration is important is that mailing yourself a copy in a sealed envelope does not count. It does not do the same thing, right? So it can be, you know, a timestamp that the work existed as of a certain date, but that's about all you get out of it, right? So mailing yourself a copy of your work and then not opening the envelope, commonly called as the poor man's copyright, that does not do the same thing as actually going to copyright.gov and registering your copyright. It's also not the same thing if you go to the website, like I showed you in the previous slides, that is obviously not the same place as ASCAP and BMI, right? So if you've gone to ASCAP and BMI and already put your music up there, that's not the same thing as having registered your copyright. So these are two totally separate things. Registering with ASCAP and BMI is not going to give you the legal protections that registering a copyright is. So very briefly, the things that you need to have in hand when you go to register: you need to have an understanding of the authorship and the ownership. So that means getting all the right contracts in place. You need to have the date of creation and the date of publication of the work. If the work isn't published, that's okay. You can still register a copyright for an unpublished work. You need to have the names of the authors and the country where they're a citizen, not because, you know, ICE is checking Copyright Office records or anything like that, but just because copyright law applies primarily to people who are either citizens or residents of that particular country. Every country in the world has their own copyright law that applies to the citizens and residents of that country. So that's sort of a technical thing, but still, when you go to sit down and register, it's a required field to enter on the form. So you need to have that info. Optional to also have their year of birth You don't need to provide that, but sometimes can be helpful. You need to have the info for the owner. Now, one thing to keep in mind here is that the owner's information will be made public record when you register the copyright. So they'll have fields there for, you know, your address, your phone number, your email. You don't have to provide all of that. If you just want to give an email address, that's fine. But just be aware that that information will be made public. And there's a good reason for that is other people are going to use the copyright records to determine who owns the copyright, because they may want to get in touch with you to license your work. They may want to pay you money for your song, and they're going to use the Copyright Office records to find out who to contact. So, you know, definitely at least put an email up there so that people can get in touch with you. You also need the registration fee. That's a required step, of course. And then after you pay the registration fee, the very final step of registering is uploading a deposit copy to the Copyright Office. So with music, for the most part, you can just upload some MP3s, but you need to have that work and it needs to be included in the registration. So you can't register a copyright to a song that hasn't been recorded yet, because you're going to need to upload that recording. If you have sheet music, you can use that, but you know, you'll only be able to register the copyright for the composition. In that case, you won't be able to get a copyright in the recording until the recording exists. All right, so now we're gonna talk, and I know that we're a little tight on time here, we're gonna talk about ways to sort of maximize your revenue here. So now that you sort of know how copyright works, why these exclusive rights are important, why the title of copyright owner is so important, you can now go out there in the world and you can start plugging your music into some of these services and other things that are out there for you. So we have performance rights organizations. They collect royalties for public performances of musical compositions. So it's only one out of those 6 rights, and it's only for musical compositions. But those royalties come in from FM and AM radio, from background music in hotels and restaurants and bars, from other people's cover versions of your song played live, not recordings. We'll talk about that. Your own live performances of your songs. So public performance royalties are a big area of revenue for a lot of musicians, and probably one of the easiest things to get set up. There's also SoundExchange, a totally separate organization that collects similar royalties, but for sound recordings. So there is, as I mentioned earlier, that limited public performance right for sound recordings. So whenever recordings are streamed or played on internet radio, SoundExchange is going to collect those royalties. And we'll talk, there's a slide on SoundExchange coming up, so we're going to get into a little more detail there. Another form of royalty that comes from the composition, not from the master, but this comes from the composition side, is mechanical royalties. So whenever a composition is copied, because it's embedded in a recording, right? You can't copy the recording without also copying the composition that's been recorded there. That duplication is known as a mechanical reproduction of the musical composition. So that generates a separate royalty that's totally, totally different from the public performance royalty. Those also come about when a song is streamed, because there are these tiny little copies being made on the servers that streaming services use and on your own computer in order for you to be able to listen to it. So mechanical royalties come up in a lot of different ways in the music industry, but they're kind of hard to track down, and they're very, very hard for artists to collect individually, but there are services out there that allow you to collect them. What was I going to say? One last thing about mechanical royalties. Those also come up if someone else records a cover of your song. Not a live performance of a cover, but they record a cover of your song and they put it out on their own album. You've got mechanical royalties coming from that. There's also money to be made from sync licensing, which could come from working directly with film productions, but it also could come through production music libraries, where you can actually submit your catalog of music to a service that other people log into as users and sort of browse around, and they say, I want a song that, you know, uses acoustic guitar and has an eerie sound to it. Okay, apply those filters and it'll come up with a list of music. They navigate it, they find something they like, they can pay for a license and download it right there. So this is an area, production music libraries have been blowing up over the past 10 or 15 years. There's a lot of different libraries out there. They're being used. There's so much audio-visual content being made these days, and all of it needs some sort of music. So this is an expanding area. And then, of course, there's digital distribution. You want to get your own music out there. You obviously need to partner with some kind of distribution service to get your music out to streaming services, downloads, stores, things like that. Okay, so public performance royalties and performing rights organizations. I don't have a formal title for this page because I figured I would just use these logos. These are the 3 performance rights organizations, also called PROs, that exist in the United States. Every other country in the world has their own performance rights organizations, because just like copyright, there are territorial limits, right? Not just like copyright, because of copyright, there are territorial limits. And so these performance rights organizations operate to serve musicians who are citizens or residents of the United States. So if you full-blown citizen, or you live here and work here and do all of your business here, these are the 3 options you have. So what they do is they issue blanket licenses. So a restaurant might want to be able to play music in their sound system, right? And so what ASCAP, BMI, and SESAC will do is they'll issue a blanket license where the restaurant gets access to the entire catalog that PRO controls. The entire catalog. That's why they call it a blanket license, because it covers the whole thing. They can't license individual songs. They have to license the whole thing. And then in turn, these organizations collect these license fees from all of the thousands and thousands of restaurants, hotels, radio stations, other places where public performances of music are being made. They collect it, they pool it all in one place. They take out a small administrative fee. ASCAP and BMI are actually both nonprofits, so they keep their administrative fees down to about 10%. So 90% of that money they collect gets passed directly on to the songwriters. So the idea here is you've got millions of songwriters, potentially hundreds of thousands of businesses who want to use their songs. We can't have people just one-on-one licenses, because it would be incredibly expensive and would take way too long. So these organizations kind of serve as the conduit in the middle, right? You've got blanket licenses going to all these businesses, and then as members of one of these organizations, you're going to get regular checks from the PRO as your song gets used. So public performances come up in, like I said, AM and FM radio. We call that terrestrial radio. Background music, live performances, including your own, TV broadcasts. So that's kind of a tricky area. There's going to be a sync license to get your music into a TV show, but then every time that episode is broadcast, there's also a public performance of your song being made. So you've got royalties coming from that. When music is played at foreign movie theaters, there is a public performance royalty, kind of a weird quirk of copyright law in the US, such that music played at US movie theaters does not generate a public performance royalty. And then from internet streaming services, there's also public performances of your songs being made, because these songs are available for anybody to press play and listen to. And then these organizations, what they do is they pay out your royalties based on, first based on how prevalent the song is. So if you write a hit song that's demanding a huge portion of, airtime on radio stations, then you're going to get a bigger piece of the overall royalties that these organizations pay out. But then once those royalties get distributed for a particular song, they get split up based on your share of authorship in the song. So if you have co-writers, it's going to get divided up in percentages among those co-writers. If you have a publisher, they're going to split up the royalties into a writer's share and a publisher's share. And they'll basically pay each of those entities separately. We're going to talk a little bit about payment 2 slides from now. So just a little bit on how to join. Got the full names of these organizations, just so you're aware what the acronyms stand for. Pricing is a little bit different, as you can see, across these different services. BMI has a separate classical division, which some classical musicians find really beneficial to have that. I think ASCAP is working on having their own as well.
Hey,
SESAC,
Matt.
yeah.
Sorry, just a voice. I'll turn my video on so I'm not just a voice. I just wanted to acknowledge that it is 1 o'clock. We are fine to keep going, and I think this information is really valuable. But I just wanted to give a quick time check and acknowledge that for our attendees and for you. We are recording this, so I'd love to just keep going through this information because I think it's valuable, but I just wanted to chime in with that right at this moment.
Great, thank you.
Okay.
Yeah, and I'm realizing that this is going to run probably another 15 minutes or so. So if people are willing to stick around and listen to this, we've got a lot of great stuff to talk about. So just quickly finishing this up, one really important thing is that you can only be a member of one PRO at a time, and it's kind of a pain in the ass to switch. So it's worth taking the time to kind of do your research and look at the different options. And once you've decided on a PRO, hopefully it's easy enough and worthwhile for you to stay with that PRO. It is possible to change, but it's just a kind of a headache of a process to get through. And so, it's better to just sort of make your choice at the beginning. All right, so moving on to the next one. So getting paid from a PRO. First, of course, you have to create an account. You have to pay that initial startup fee. Those are one-time fees. So, the $50 for ASCAP, 50 to join as a songwriter, 50 as a publisher. BMI is free to join as a songwriter, but not free to join as a publisher. So those fees are all one time, not annual or anything like that. So you got to, create your account. When you create that account, one thing to be aware of is that you are granting these organizations a license to your public performance right, because they're going to then turn around and license your public performance right out to other people. So as part of your membership in an organization, you do give up your control over one of those 6 rights in your copyright. You're basically putting the public performance right in the hands of your PRO, which is okay because they're going to then turn around and make some money for you. So just be aware that there is that trade-off going on, and you don't really get the right to stop other people from making public performances of your song if you're a member of ASCAP or BMI or SESAC, because you've essentially granted the world, or anybody who pays a blanket license at least, access to public performances of your songs when you join these organizations. The next thing you'll have to do once you have an account is you have to actually register your songs with them. So you're gonna have to go through your entire list of songs, figure out who are the authors. If there's any publishers involved, you have to make sure you get the publisher information, and you have to input the names of the writers as well as their percentages of ownership. It's helpful to get their IPI number, which is a special identifying number that that the PROs use to make sure that they've identified the correct person. I don't think it's absolutely required that you input the IPI number, but it will help make sure that you're actually getting the right person. If someone's not a member of a PRO and they're a co-writer of your song, you can still list their name, but they're not going to see those royalties until they create an account. So still probably a good idea if you have co-writers to make sure you include their names. That way you're not sort of misrepresenting to the world that you own all the rights when in fact you co-own them with other people. So put their names in there, but there's a limit on what they'll be able to get out of that themselves if they don't create an account. And then this is an optional third step. Both BMI and ASCAP have a relatively new program. I guess it's not that new anymore. It's been around for 6 or 7 years, that allow you to basically get paid from your own live performances. So when you are playing at a venue, which obviously isn't happening too much right now, but you can report to BMI or ASCAP, whichever one you're signed up with, your live performances and which songs you played and which venue and what date, and they will pay you for those performances. One thing that's really good about this is that this program, the BMI Live and ASCAP on Stage, they bypass the standard algorithm that BMI and ASCAP use to compute what share of the total pot of royalties you're supposed to get, right? So when they're pulling in millions and millions of dollars in public performance royalties, they have these very complex algorithms and sampling methods and other things to determine what share of the listening market do your songs have, right? So if based on their algorithms, you're entitled to some, 0.5% of the total pot of royalties that they are holding on to, then your royalty payment will be computed based on those algorithms. But with BMI Live and ASCAP on Stage, it bypasses that and actually pays you directly based on your songs. In my experience working with clients, you're looking at sometimes $2 to $3 per song per performance. So if you're really on top of it and you're uploading all your set lists and all your shows to BMI Live, you can pull in an extra couple $100 just from that alone. And that's separate from all the other public performances that your song might be getting from radio play and from other outlets. Note that this will not affect your payment from the venue. So if you've got a guarantee of $500 from the venue, you get that money from the venue. You separately go to BMI Live and report your show. BMI Live is going to pay you the money from that. And those are just two totally separate revenue streams. So it's a way to basically get an extra bonus for every gig you play. Now, obviously there aren't any gigs happening right now and haven't been for the past couple of weeks, but you can report up to the past 6 months worth of shows. So if you were playing shows throughout the winter and the early part of the spring before stuff started closing down, you can still log on to BMI Live or ASCAP on Stage and upload your set lists and get paid for that. So it's literally never too late to submit, assuming you have shows within the past 6 months. And so that's something to really look into. One thing to note, you will need to input your bank account information for BMI Live because direct deposit is the only way that they pay through these live programs, the BMI Live and ASCAP on Stage. You don't need that for your standard ASCAP BMI accounts, but you do need it for these special programs. They only do direct deposit. So changing gears to SoundExchange. SoundExchange essentially functions like a PRO, but for masters. Okay, so the same concept. You've got all these businesses and other places that are making public performances of your songs and your recordings. They pay into one single entity, and then that entity, which in this case is SoundExchange, in turn goes and distributes that money according to who has earned it, right? The only thing is that sound recordings, as I mentioned earlier, have this limited public performance right. It's only for digital audio transmissions, so streaming and internet radio. So there's not as many players there, but still, would be really difficult for all of those services to individually license recordings from artists. It's a lot easier to just go to one place, which is SoundExchange, and do that. SoundExchange is free to join, unlike ASCAP and BMI and SESAC. You can sign up as an individual artist. You can sign up as a band. You can sign up as a copyright owner. So if you're both the owner and the artist, you actually have access to two separate royalty streams that SoundExchange will pay out. If you run a record label, you can create a record label account. If you are an heir of a musician or performer who is deceased and never created a SoundExchange account, you can actually sign up as an heir and go and claim their royalties that are sitting there. SoundExchange has been collecting royalties for years, even even though plenty of people haven't signed up. So there's a running list of unclaimed royalties. And once you create your account, there may actually be royalties sitting there waiting for you. So like I said, free to join. And as long as you have recordings that are out there being streamed, being played on internet radio, there are royalties being generated. Not necessarily a huge royalty rate, it's some fraction of a penny, but it's something. And if your music is out there and generating these royalties anyway, you're basically leaving money on the table if you don't sign up with this, right? So one interesting thing here is that SoundExchange also pays out royalties to studio musicians and backing vocalists and other people who played on a record, even if they're not the copyright owner. And it's kind of a weird concept, but the idea is that there should still be some compensation for these musicians when a recording is essentially being used in place of a live performance. And so that's sort of the theory there. So the way that SoundExchange pays out is 50%. If you take a particular recording, the revenue generated from that particular recording gets split up 4 ways. You got 50% going to the copyright owner, 45% goes to the featured artist. So that could be an individual artist who's the vocalist, or it could be the entire band if the record is released under the band's name, not under an individual person's name. So if you're the owner and the artist, you're getting 95% of that pie, right? But then there's also these 2 collective funds that SoundExchange pays out to. There's one run by the American Federation of Musicians, Musicians Union. And there's a separate one run by SAG-AFTRA, the Actors Union. And SoundExchange pays out 2.5% to each of those. They get pooled together. And the AFM fund, in turn, takes that money and they pay it out to the session musicians. So the session musicians will still get a little piece of these streaming royalties from recordings just by having played on the record, even if they've signed a session musician agreement and given up their ownership of copyright and all of that. They're still going to see some money coming through this. And then the SAG-AFTRA fund, which also gets 2.5%, pays out to backing vocalists. Again, even if they've signed away their rights, by being a backing vocalist, they're going to get some royalties through the SAG-AFTRA fund. All right, so that's SoundExchange and the PROs. And if anyone has any questions about those, we can definitely talk about that. But moving on, there are some royalties that come from streaming that are just flat out not collected by PROs at all. Okay, so we talked a little bit earlier about mechanical royalties. Public performance royalties and mechanical royalties are both derived from the musical composition. They're both derived from the musical composition, but they're 2 separate royalties and they come up in 2 different contexts. So AM and FM radio, all those other things I mentioned earlier, that's public performance. PROs are going to collect that. Mechanicals are generated from things like downloads and streaming and physical sales, and PROs do not collect those. So there are some services out there, two of which I'm very familiar with are Songtrust and TuneCore. TuneCore is also a distributor, but they have a relatively new service where they can collect your mechanical royalties for you. Both of these services, I think they actually don't charge you anything up front, but they just keep a portion of the royalties that they collect. So you're not coming out of pocket to work with them, but they're going out and getting royalties that are otherwise out there in the world and not coming to you. So there's a lot of value there in looking at that. One thing to know about SoundExchange that I didn't mention earlier, you'll notice here that digital audio transmissions are actually split into what are known as interactive streaming and non-interactive streaming. So interactive streaming is like Spotify, right? Where you get to pick what song you play, you can stop and start it, you can switch to another song whenever you want. Non-interactive streaming might be something more like Pandora, where, yeah, you can skip ahead, but when you start a radio station, that's pretty much what you're going to get.
Hey, Max.
Yeah.
Max, we have a question from David. He wants to know, how do I assign myself as a side person to recordings under a different artist's name? Does that make sense? Do you want me to repeat it?
I'm not sure that I really understand the question. I'd be happy to have David maybe unmute and clarify what you're getting at.
Sure, that's fine. All right, David, I'm going to unmute you. I'm going to give you permission to talk so you can ask your question. You are unmuted, David.
Can you hear me? Hello?
Yep.
Hey.
Oh, great. Hi. First of all, thanks for doing this. I'm learning a whole heck of a lot here that I wasn't aware of. So thank you. Mm-hmm. And this question is in regards to what you were talking about, or just about like 2 minutes earlier when you were talking about musicians and or vocalists being eligible for royalties on recordings that they are not the artist of. Mm-hmm. And I'm wondering, as a personal example, I play in a band as a guitarist that is somebody else's trio under his name. Mm-hmm. How, in the digital realm, how is it known that I am a side person on that recording and am therefore eligible for that 5% of royalties?
Yeah. So if you're just an instrumentalist, it's only going to be that 2.5%.
Or 2.5, sure, yeah.
Because half of it goes to backing vocalists. But most of that you would do through SoundExchange. So when you create an account, they're also going to ask you to input all the information you have on what recordings you played on. And so, some of it obviously does depend on people being truthful and straightforward and not, defrauding the SoundExchange system. But yeah, basically the ASCAP are part of. And then the other thing kind of related to that is that there is a system of codes that are used in the recording industry, and they're used by streaming services, called ISRC codes. And each unique recording can get its own ISRC code. So normally it's the band leader or kind of whoever's handling the administrative stuff who's going to obtain the ISRC codes from the RIAA. But if you have those ISRC codes in hand when you go to the Copyright Office and register your copyrights, you can actually enter the ISRC code as part of the copyright registration. And then when you do that, your copyright records at the US Copyright Office will always have that ISRC code also listed. And that's the primary method that SoundExchange and the streaming services use to identify the copyright owners of those particular recordings. So when Spotify, Spotify is not a good example because interactive streaming, but SoundExchange collects non-interactive streaming. So if these records are played on Pandora, Pandora is sending, either quarterly or annual reports to SoundExchange of what got played and what the streaming numbers were and all of that for each individual recording. And they're going to have that ISRC code as well. And they'll cross-reference that with the SoundExchange database, which basically is the US Copyright Office database. And that's how they'll make sure that royalties are going to the right recording. So then you, as a side person, if you have already entered all of this information that, these 10 recordings feature me as a session player, then when those royalties come in from Pandora and then get paid out by SoundExchange, they'll already have that information linking you to those songs. So it's a little bit complicated, and I know there's a lot of different steps there, but basically they take your word for it, and you enter the recordings that you were on. That makes sense. So
to enter that, I think I get it. To enter those past recordings that I've been on as a side person, I would need the ISRC code for each individual song that I have played on in the past, and that's how I register?
I don't know for sure if that's correct, because that would be a pretty high hurdle for a lot of session musicians to get over. So I think that you can just enter the name of the recording and whoever the featured artist was. And if you do have things like the year it was released and the label and things like that, they'll ask you to put that in as well. Just, you know, the more detail you can give, obviously the more, you know, certain we can be that they're accurately getting the right recording connected to your name. I don't think that having the ISRC code in hand is required for you as a side person. It's mostly something that has to be done by whoever the copyright owner is during the registration step, like when you go to the Copyright Office and register the copyrights. If you do have the ISRC codes, or you're able to get them, it definitely helps. Like it certainly wouldn't hurt, but to my knowledge, I don't think that it's required, but I can definitely double check that.
Cool, thank you.
Mm-hmm. Of course. Okay, so getting back to this slide we've got pulled up here. So some streaming royalties are not collected by PROs. We talked about mechanicals. And since we were talking about SoundExchange, let's just get back to that. So there's interactive and non-interactive, right? So SoundExchange only collects non-interactive streaming royalties. And it's kind of a weird quirk. There's a whole complicated area of the copyright statute that deals with this, but that's just what it is. They only collect from non-interactive. So interactive streaming royalties like Spotify and Tidal and Deezer, which obviously is only in Europe, not here, but you know, other interactive streaming services, those royalties are not getting collected by SoundExchange. Those are actually getting collected directly by the labels and the distributors who have partnered with those streaming services. So if you don't have a deal with a label, and you know, independent small labels might not really count here, but a deal with a label that is directly working with a streaming service, or is maybe part of a larger company that is working with the streaming services, then you're pretty much not going to see these interactive streaming royalties unless you have a digital distributor who collects those. So that's where these partnerships with digital distributors is really important, which actually is the next slide. They're not only getting your music out there for people to listen to, but they're also directly tracking how much your song is getting streamed, downloaded by, you know, at the Google Play Store and Amazon Music and things like that. And then turning around and making sure that you're getting those royalties that are being generated. So on the master's side, with these interactive streaming services, you've got your recording being played whenever somebody is streaming it. Those interactive streaming royalties are going to go directly to your distributor or to your label, who should be then paying you a portion of that, depending on whatever your contract is with that label or distributor. So we already talked about how to collect mechanicals. If anyone needs to be put in contact with TuneCore or Songtrust, I do have contacts at both of those places and can help get you connected. And then there's also something I actually just learned about fairly recently. There are these two collective funds for musicians who either feature in films, like you are on camera performing a song, or who compose music for films. There's a musicians fund that's a joint project of AFM and SAG-AFTRA, and the link is there for you to check it out. And then there's the Film Musicians Secondary Markets Fund, which is for film composers, and specifically collects royalties that come from the secondary market, so DVD sales, streaming, video on demand, things like that. The primary markets in film are, you know, your theatrical releases, right? So for all the secondary markets where money is kind of coming in as sort of a slow trickle rather than sort of the big box office numbers, there is this fund that collects those royalties on behalf of all music film composers and pays them out similarly to how sort of the PROs work, right? It's proportional again, they have lists of unclaimed royalties, and it's actually a publicly available list. So you can go to these websites and check to see if your name is on the list. If you have featured in a film or you have composed music for a feature film, your name might actually be on these lists. One thing there is that these funds are not just generally accessible to anybody. You have to have been in a qualifying production or been part of a qualifying production, and then you will be automatically included. These are not the kinds of things you can just go sign up for the way you can sign up for ASCAP or sign up for SoundExchange. So digital distributors, also sometimes referred to as aggregators. The idea there is that you work with one partner who then sends your music out to a whole bunch of platforms. So that's why we call it aggregators, is they collect everything all in one place. There's a lot of different options out there. Some of the two most well-known, or really two of the oldest ones, are CD Baby and TuneCore. They were around before streaming existed. They used to be the only way that you could get your music on the original iTunes store, is if you worked with one of these two companies. CD Baby's model is a little bit different, where they also have a platform for their own online store. And they even do things like CD duplication, things like that. So CD Baby can be, if it's an option that works for you, it can be kind of a one-stop shop where you can get digital distribution, physical distribution, well, not quite physical distribution, but at least physical product manufactured, and an online store of your own set up, which is a sort of bundle of services that you're not really going to get from any of the other distributors. TuneCore is really just straight ahead digital distribution. But like I mentioned earlier, they have these additional services. So you can sign up for TuneCore just for digital distribution, or you can also choose to add on their publishing administration service, where they'll collect mechanical royalties for you as well as your streaming royalties. So some options there. Some of the other distributors out there that are a little bit newer are DistroKid, iMusician. Those, I have some personal experience with both of those, and they are both very cheap and very straightforward. There's not really a whole lot of extra features with those, but if all you're looking to do is just get your music out there and make sure that your royalties are being collected, those could be good options. There's a sort of more sophisticated distributor called AWOL. It's actually invitation only. I didn't know that at first, but when I went to look into it a little bit more, I found out that they're invitation only. And over the past year or so, Spotify has been expanding their Spotify for Artists section, which at first was basically just a place to see data on, where your music was being played. But they're sort of beta testing some direct upload options and some things like that. So before too long, you might just be able to upload your music directly to Spotify without having to go through a distributor. I don't know how royalty collection is going to work there, because you'll put yourself in a situation where you're just a single individual artist with Spotify on the other side of the table, which doesn't really give you as much bargaining power as being partnered with one of these other aggregators. So that's an area that definitely needs some researching before diving headfirst into that, but just wanted to make you aware that that's an option. All of these distributors, different pricing plans, some charge flat fees, some charge an annual fee, some are just one-time payments, some take a percentage of royalties as their payment, others don't take a percentage of royalties at all. So a lot of different options, and you really just have to do some research and do some comparing to figure out what makes the most sense for you. One thing to be aware of is that once you do sign up with a distributor, they have quite a bit of control over your work. They're going to be the ones getting your music out to streaming platforms. It's not very easy for you to sort of take stuff down once the distributor has put them up. In fact, I worked with an artist a couple of years ago using CD Baby as the distributor, and we wanted to take the music down from one particular platform, but not from all of them. And it basically wasn't an option. CD Baby said you had to essentially cancel your account and restart and totally re-upload the music. So, you know, not to say that that's always what's going to happen with CD Baby. They definitely do work with people individually to help solve customer service issues. But just so that you know, I mean, similar to the PROs, when you sign up with a digital distributor, you are granting a copyright license to your work. And once you give someone else a license, it gives them permission to do certain things with your work. So just be aware that that's what's happening when you sign up there. You do also want to look out for any exclusivity provisions. So if you're dealing with a distributor who requires exclusivity, but then maybe a year or two later you get courted for a record deal, you might have to fully terminate your relationship with the distributor before you can sign your record deal, because you don't want to get yourself into a breach of contract situation. So not that that's always going to come up or that that's something that happens with every distributor, but you should be aware that that could be there. And so it's something to look out for in the contract. And then the last slide we're going to talk about here is mechanical royalties, just getting into this in a little bit more detail. Like I've said a few times, this is different from your public performance royalty, but it's still derived from your composition. So there's no mechanical royalties from your masters. It's only from the composition side. The term mechanical royalties means something specific, and so you have to know that that is specifically connected to your musical composition copyrights. Mechanical royalties are earned every time a song, not a recording, but a song is streamed, downloaded, or a physical copy is sold. So that means any recorded version. So a classic example that I use in these workshops all the time, a lot of people are familiar with the Whitney Houston song, I Will Always Love You, right? The thing is, Dolly Parton wrote that song and recorded it and released it some